plaintiffs against Illinois' gun and magazine ban filing a list of the experts they hope to include in their challenge of the state's ban on magazines over certain capacities, on attachments of certain firearms, on more than 170 semi-automatic rifles, handguns, and shotguns. We've been tracking this really since before the law was enacted January of 2023. And every step of the way as this lawsuit persists, challenging Illinois' gun and magazine ban. Welcome back. I'm Greg Bishop. Thanks for hanging out with me. Hopefully you had a good Easter. And as we've been tracking the latest in the gun and magazine ban and the litigation against it, listen, I mean, we've got so many different angles that this has gone, right? We tracked the Illinois Supreme Court hearing of this under the Calkins case, the trajectory of that, the questions of conflict of interest at the Supreme Court of Illinois. You've got the Northern District cases with Beavis v. Naperville, including Illinois, going to the U.S. Supreme Court several times, asking them to intervene. You've got the Southern District of Illinois cases that are consolidated, 4 of them altogether, where you had a preliminary injunction in place. All right, recall, when was that? It was late April, early May of 2023 when Judge Stephen McGlynn issued that preliminary injunction. We're approaching that 1-year anniversary when that 6-day injunction was issued that some of you out there called Freedom Week because it essentially put the law on hold, but again, it was only for 6 days. Before it went up to the 7th Circuit Court of Appeals, and then they took the case, they heard the case, they ruled in favor of the states on a preliminary basis, kicking the case back down to the Southern District, where we're currently at in the Southern District Federal Court. So we've been tracking that as well, because Judge Stephen McGlynn, he even denied some of the plaintiffs' groups that were wanting to delay the case so that they could go and request the U.S. Supreme Court intervene. Judge Stephen McGlynn in the Southern District said, no, we're moving forward with this on the merits. So with that, you've got the merits of the case starting to come together and the discussions between the plaintiffs and the defense, the state, saying, okay, here's the witnesses we want. Here's some of the evidence we hope to present during trial. Again, this is on the merits. This is the meat and potatoes of the case, not on preliminary questions of, can we please have a temporary hold on the law while we debate these things in the lower court. That's all done. Now it's time to debate these things in the lower court, according to Judge Steve McGlynn. So here we are with the latest filing from the Langley plaintiffs, representing several of the other litigants in this case. And this was filed late last week in the Southern District of Illinois. And I'm just going to go through this because it's the Langley plaintiffs' expert witness disclosures. This will give you a sense of some of the arguments that are going to be made here in the Southern District Federal Court. All right, so the Langley plaintiffs submit this evidence witness disclosure with the understanding that supplemental expert witness identification and rebuttal expert witness identification may become necessary as the case proceeds, and in addition to those previously disclosed. Who are the plaintiffs, at least the Langley plaintiffs, hoping to call as expert witnesses? J. Buford Boone III heads Boone Ballistics LLC. He's a retired supervisory special agent of the Federal Bureau of Investigations and was the primary agent, special agent with oversight of the FBI's ballistic research facility. Mr. Boone will offer testimony about the ballistics of firearms banned by the Protect Illinois Communities Act and their suitability for various lawful purposes, including self-defense. Number 2. The next witness they hope to bring, Paul Leitner Wise is a firearms designer, firearm manufacturer, and firearm patent holder. Mr. Leitner Wise will testify as to the mechanical distinctions between select fire rifles like the M16 and semi-automatic only rifles like AR-15 variants that the Protect Illinois Communities Act bans. David A. Lombardo is president and founder of Safer USA, a Chicago-based firm training school founded in October of 2006. Safer USA has trained thousands of students on concealed carry and tactical firearm use. Mr. Lombardo will offer testimony as to the popularity and ubiquity of firearms banned by PICA in self-defense training courses and the utility of those firearms for self-defense and other lawful purposes. Ubiquity being it's all over the place. right? Randy Watt, another expert that the plaintiffs are looking to get. Former chief of police of the Ogden Police Department. He has a total of 32 years of service as a law enforcement officer, including 12 years in SWAT and 15 years as the primary firearms and defense tactics trainer in the Training Bureau. He's a published author and a trainer of police leadership at various levels in federal, state, and local law enforcement. Mr. Watt will offer testimony as to the popularity and ubiquity of firearms banned by PICA in self-defense training courses and the utility of those firearms for self-defense and other lawful purposes. Interesting that they keep putting their self-defense, right? And I think one thing you hear a lot when debating this, and you've heard, everybody from U.S. Senator Dick Durbin to then Vice President Joe Biden talking about how, well, you don't need 100 rounds in a clip to go deer hunting. If you need 100 rounds in a clip, then to hunt a deer, you're not really good at hunting. Well, we can have the debate about clip versus magazine, but that might be for another day, right? I think really the crux of the criticism of those kind of comments is the Second Amendment says nothing about deer, says nothing about even coyote. It's, a well-regulated militia being necessary for the security of a free state. The right of the people to keep and bear arms shall not be infringed. Again, nothing in there about game shooting, skeet shooting, target practice, or anything like that. Anyways, all right. So I think it's interesting that you've got the plaintiffs here regularly injecting this for self-defense and other lawful purposes. All right. So you're seeing a theme here all throughout this list of experts that the plaintiffs are hoping to get in this case. Continuing on, Matthew Little, U.S. Army Special Forces combat veteran who has extensive law enforcement experience, including serving as training coordinator and operational supervisor on a major metropolitan SWAT team, and has worked as government contractor in non-permissive environments. He's also ranked as a master class shooter with a pistol and carbine by the U.S. Practical Shooters Association, the Steel Challenge Shooting Association, and the International Defense Pistol Association. Mr. Little has instructed foreign and U.S. military personnel and police officers, martial artists, and civilians. Mr. Little will offer testimony to the popularity and ubiquity of firearms banned by PICA in self-defense training courses and the utility of those firearms for self-defense and other legal purposes. Jeffrey Eby reached the rank of Chief Warrant Officer 5, having served 28 years in the U.S. States Marines, including 11 years as a Marine gunner. He saw combat in Iraq and officer in charge of the USMC Small Arms Instructor Course, which developed the USMC Combat Marksmanship Program. Mr. Eby will offer testimony as to the nature of firearms and ammunition that are used and not used in the military. Because again, what you have is some of the arguments that the judge has laid out here, taking from the Seventh Circuit, saying, hey, the Seventh Circuit started talking about, these are firearms, weapons for military use versus civilian use, and is that the line that we're trying to draw here? As if it's used by the military, civilians can't have it. Well, that might take out a whole host of different semi-automatic pistols, let alone, pump-action shotguns, and a whole host of other things. But that apparently seems to be the question. So looking at the experts that the plaintiffs are wanting to bring in the Southern District gives you a sense of kind of what they're aiming to do. Right? No pun intended. Continuing on here, Mike Musselman also reached the rank of Chief Warrant Officer 5 and was infantryman for 25 years out of 30 years with the United States Marine Corps. He served as a Marine gunner and as an infantry weapons officer and did 3 combat deployments to Iraq and another in Afghanistan. Mr. Musselman will offer testimony as to the nature of firearms and ammunition that are used and not used in the military. Daniel G. Kemp, U.S. Army veteran with deployments in Korea, Kosovo, Iraq, Afghanistan, and was last assigned to the 101st Airborne Air Assault Division and is currently an instructor operating primarily at Fort Campbell, Kentucky. Kemp is a military firearms collector and historian and will offer testimony in the nature of firearms, ammunition, accessories, and related items that are currently used in the military and those that are not used in the military. Again, you're seeing a theme here, and the themes seem to be arms that are used by the military, arms that are not used by the military, arms that are practical for self-defense and training, arms that aren't practical for self-defense and training. So interesting to see, again, some of these themes that they're working through. Kemps is a military firearms collector and a historian, and will offer testimony about the nature of firearms, ammunition, accessories, and related items that are currently used in the military and those that are not, as well as historical military and civilian firearm usage, their development and their crossover of use and development, as well as their relative effectiveness for armed confrontation, including self-defense. Another expert they're going to hope to bring for the plaintiffs in the case in the Southern District, Michael Dennis, a retired chief of police and current licensed FFL gunsmith. Mr. Dennis will offer testimony in the nature of firearms he has used and confronted in law enforcement career, as well as his knowledge and experience with the effect of gunshot wounds from both his law enforcement career and his prior career as a paramedic. Mr. Dennis is a firearms instructor and will express knowledge and opinions on the kind of firearms useful for self-defense and his observations of same. So again, that was filed late last week. That's what some of the plaintiffs are looking for. We, of course, will give you as much as we can in that case in the Southern District of Illinois Federal Court, as we also await for any kind of announcement from the U.S. Supreme Court as to if they're going to take this case and intervene, what that could possibly do to the case in general. It's just it's fascinating, and hopefully you're here checking in on a regular basis. All right, like, subscribe, hit that notification bell. It's Bishop on Air. Greatly appreciate you guys being here each and every weekday morning.